Lawyers, what are the 45 most shocking lawsuits that changed everything? Story 1. Brown v. Board of Education, 1954. The lawyers representing Linda Brown and 12 other black families from Topeka knew they were challenging 58 years of legal precedent. These children were forced to walk miles past neighborhood schools to attend segregated facilities simply because of their race. The school board defended this under Plessy v. Ferguson's 1896 separate but equal doctrine. Led by NAACP attorney Thurgood Marshall, the legal team presented groundbreaking social science evidence demonstrating how segregation psychologically damaged black children, instilling feelings of inferiority. The district court ruled against them, citing Plessy as binding. But the lawyers persevered to the Supreme Court, which consolidated their case with 4 similar lawsuits from other states. On May 17, 1954, Chief Justice Earl Warren delivered a unanimous 9-0 decision that transformed America. Separate educational facilities are inherently unequal, he declared, overturning Plessy and ruling that school segregation violated the 14th Amendment's Equal Protection Clause. The victory ignited the modern civil rights movement, though massive resistance would follow across the South. Story 2. Dred Scott v. Sanford, 1857. The attorneys representing Dred Scott, an enslaved man, believed justice was clear. Scott and his wife Harriet had lived in Illinois and Wisconsin, free territories under the Missouri Compromise, before returning to Missouri. Missouri law had long recognized that slaves became free when taken to free territory and couldn't be re-enslaved upon return. Scott's legal team won a trial in 1850, but owner Irene Emerson appealed to the Missouri Supreme Court, which reversed the victory in a pro-slavery political decision. When the case reached the U.S. Supreme Court in 1857, Chief Justice Roger Taney delivered one of the most infamous decisions in American legal history. The 7-2 ruling declared that black people, enslaved or free, could never be citizens and had no standing to sue in federal court. Worse, Taney ruled the Missouri Compromise unconstitutional, holding that Congress couldn't prohibit slavery in territories. This decision didn't just deny the Scots their freedom. It accelerated the nation towards civil war by declaring slavery could spread unchecked throughout America's western territories. Story 3. Loving v. Virginia, 1967. The lawyers representing Richard and Mildred Loving faced a straightforward case of injustice. This couple, married legally in Washington, D.C. in 1958, returned home to Virginia where their interracial union violated the Racial Integrity Act of 1924. Sheriff's deputies raided their bedroom at night and arrested them. The trial judge sentenced them to a year in prison, suspended only if they left Virginia for 25 years, infamously declaring that Almighty God didn't intend races to mix. The legal team argued this violated the 14th Amendment's due process and equal protection clauses. On June 12, 1967, the Supreme Court unanimously agreed in a landmark 9-0 decision. Chief Justice Warren wrote that Virginia's anti-miscegenation law served no legitimate purpose except white supremacy. The ruling invalidated similar laws in 16 states, affirming that marriage is a fundamental right that cannot be restricted based on race. The Lovings simply wanted to live together peacefully. Their lawyers helped them achieve that while liberating millions of Americans from racist marriage restrictions. Story 4. Obergefell v. Hodges, 2015. The legal team representing Jim Obergefell took on a heartbreaking case with profound implications. Obergefell's partner, John Arthur, was dying of ALS, so they flew to Maryland to marry legally since Ohio wouldn't recognize same-sex unions. When Arthur died 3 months later, Ohio refused to list Obergefell as the surviving spouse on the death certificate, erasing their love even in death. The lawyers filed suit alongside 36 other couples from Michigan, Kentucky, Ohio, and Tennessee, arguing that state bans on same-sex marriage violated the 14th Amendment. The legal battle reached the Supreme Court, where on June 26, 2015, Justice Anthony Kennedy delivered a historic 5-4 decision. "The Constitution promises liberty to all," he wrote, finding that marriage is a fundamental right that cannot be denied to same-sex couples. Kennedy eloquently stated these couples ask for equal dignity in the eyes of the law. Within hours, same-sex marriages were being performed nationwide, culminating decades of LGBTQ+ advocacy and ensuring equal treatment under the Constitution. Story 5. Shelley Five Kramer, 1948. When lawyers represented J.D. and Ethel Shelley, a black family who'd purchased a St. Louis home in 1945, they discovered a hidden barrier. A 1911 restrictive covenant prohibited people of the Negro or Mongoloid race from owning property in their neighborhood. White neighbor Louis Kramer sued to enforce this racist agreement signed by 30 homeowners decades earlier. The legal team crafted an ingenious constitutional argument. While private discrimination might be legal, court enforcement of such covenants constituted state action, violating the 14th Amendment's Equal Protection Clause. The Missouri Supreme Court disagreed, but the lawyers appealed. On May 3, 1948, the U.S. Supreme Court unanimously sided with their reasoning in a landmark 6-0 decision. 3 justices recused. Chief Justice Vinson confirmed that judicial enforcement of these covenants was indeed unconstitutional state action. While the ruling didn't eliminate private racial covenants or end housing discrimination completely, it removed courts' power to enforce them, a crucial stepping stone toward Brown v. Board and the broader dismantling of America's apartheid system. Story 6. Jones v. Alfred H. Mayer Company, 1968. The attorney representing Joseph Lee Jones saw racial injustice in a simple home purchase denial. Jones, a black man, wanted to buy in the Paddock Woods subdivision near St. Louis, but the Alfred H. Mayer Company refused to sell to him solely because of his race. The lawyer filed suit under the Civil Rights Act of 1866, an obscure Reconstruction-era statute rarely invoked in a century. The developers argued it only applied to state action, not private discrimination. But Jones's attorney believed Congress had broader authority under the 13th Amendment's abolition of slavery. Lower courts dismissed the case, but the legal team persevered. On June 17, 1968, just weeks after Dr. King's assassination, Justice Potter Stewart delivered a groundbreaking 7-2 decision, resurrecting this century-old law. The court ruled the Civil Rights Act of 1866 prohibited all racial discrimination in property sales, public or private, declaring that badges and incidents of slavery included restrictions on property rights. This decision strengthened the Fair Housing Act being debated in Congress, providing powerful legal tools to combat housing discrimination nationwide. Story 7. Regents of the University of California v. Bakke, 1978. Alan Bach's attorney challenged the University of California Davis Medical School's admission policy that reserved 16 of 100 spots for minority applicants. Bakke, a white applicant with strong credentials, was twice rejected, while minority students with lower scores were admitted through the special program. His lawyer argued this racial quota system violated the Equal Protection Clause and Title VI of the Civil Rights Act. The case reached a deeply divided Supreme Court in 1978. Justice Lewis Powell's pivotal opinion produced a complex 5-4 decision that pleased no one completely. The court ruled that strict racial quotas were unconstitutional, ordering Bakke's admission. However, Powell held that race could be considered as one factor among many in admissions to achieve diversity, a compelling government interest. 4 justices wanted to ban any consideration of race. 4 wanted to uphold the quota system. Powell's compromise acknowledged both the harm of racial preferences and the value of diversity in education. The decision sparked decades of debate over affirmative action, establishing standards that governed college admissions for generations. Story 8. Batson v. Kentucky, 1986. James Batson's defense attorney faced an all-too-familiar problem in 1981. Prosecutors systematically excluded black jurors using peremptory challenges. Batson, a black man charged with burglary in Kentucky, watched as the prosecution struck all 4 black potential jurors, resulting in an all-white jury that convicted him. His lawyer argued this violated the Equal Protection Clause, but Kentucky courts disagreed, citing the long-standing rule that peremptory challenges didn't require explanation. The case reached the Supreme Court during an era of heightened awareness about racial discrimination in jury selection. In 1986, the court delivered a 7-2 decision, establishing what became known as the Batson Challenge. Justice Powell wrote that prosecutors cannot use peremptory strikes to exclude jurors based solely on race, as this violates both the defendant's rights and the excluded jurors' equal protection rights. The ruling created a 3-step process. Defendants could raise objections. Prosecutors must provide race-neutral explanations, and judges must determine if discrimination occurred. This landmark decision transformed jury selection nationwide, though proving discriminatory intent remains challenging. Story 9. United States v. Windsor, 2013. Edith Windsor's attorneys took on the federal government after Windsor was hit with a $363,000 estate tax bill when her spouse, Thea Spire, died. The couple had married legally in Canada in 2007 after 40 years together, and New York recognized their marriage. But Section 3 of the 1996 Defense of Marriage Act, DOMA, defined marriage as only between a man and woman for federal purposes, denying Windsor the spousal exemption from estate taxes that heterosexual couples received automatically. Her legal team argued DOMA violated the Fifth Amendment's Due Process Clause by treating legally married same-sex couples as unmarried for federal benefits. The case reached the Supreme Court in 2013. Justice Anthony Kennedy, writing for a 5-4 majority, struck down DOMA's Section 3 as unconstitutional. Kennedy found the law's principal purpose was to impose inequality and denied same-sex couples equal dignity under federal law. The ruling required the federal government to recognize same-sex marriages performed in states where they were legal, opening access to over 1,000 federal benefits and protections. Story 10. Pigford v. Glickman, 1999. The lawyers representing black farmers in this massive class action lawsuit documented decades of systematic discrimination by the U.S. Department of Agriculture. Lead plaintiff Timothy Pigford and thousands of other black farmers had been routinely denied loans, assistance, and disaster payments that white farmers received, forcing many into bankruptcy. The legal team compiled overwhelming evidence that USDA officials had deliberately discriminated in violation of the Equal Credit Opportunity Act and civil rights laws. Filed in 1997, the case exposed how federal agriculture programs had systematically excluded black farmers since the 1980s, accelerating the loss of black-owned farmland. In 1999, Judge Paul Friedman approved a consent decree requiring the government to pay $50,000 to each farmer who could prove discrimination, or up to $250,000 for those who went through arbitration. The settlement ultimately reached approximately $1.25 billion, one of the largest civil rights settlements in U.S. history. Though many farmers felt the compensation was inadequate given decades of discrimination, the case acknowledged systemic racism in federal farm programs and provided some measure of justice to families who'd lost their land and livelihoods. Story 11. Miranda v. Arizona, 1966. Ernesto Miranda's defense attorney faced an uphill battle after his client confessed to kidnapping and rape following 2 hours of police interrogation in Phoenix. Miranda, who had not been informed of his right to remain silent or to have an attorney present, signed a written confession that became the primary evidence securing his conviction and 20 to 30-year sentence. The lawyer appealed, arguing the confession was obtained in violation of the Fifth Amendment's protection against self-incrimination and the Sixth Amendment's right to counsel. The Arizona Supreme Court rejected this argument, but the U.S. Supreme Court agreed to hear the case alongside 3 similar cases involving custodial interrogations. On June 13, 1966, Chief Justice Earl Warren delivered a landmark 5-4 decision, establishing what became known as Miranda rights. The court ruled that prosecutors cannot use statements from custodial interrogation unless police first warn suspects of their rights and obtain a knowing, voluntary waiver. This created the now famous Miranda warning that police must recite before questioning suspects. Though controversial, the decision transformed American law enforcement procedures nationwide, balancing effective policing with constitutional protections. Story 12. Gideon Fee Wainwright, 1963. Clarence Gideon's handwritten petition from a Florida prison cell caught the Supreme Court's attention in 1962. Gideon, a poor drifter accused of breaking into a pool hall, had asked the trial court to appoint him a lawyer because he couldn't afford one. The judge refused, citing Florida law that only provided attorneys in capital cases. Forced to represent himself, Gideon was convicted and sentenced to 5 years. From prison, he wrote to the Supreme Court arguing that denying him counsel violated the Sixth Amendment. The court appointed Abe Fortas, later a justice himself, to represent Gideon. Fortas argued that the right to counsel is fundamental to a fair trial and should apply to state courts through the 14th Amendment. On March 18, 1963, the court unanimously agreed in a 9-0 decision written by Justice Hugo Black. The ruling established that states must provide attorneys to criminal defendants who cannot afford them, overturning Betts v. Brady, 1942. Gideon was retried with a lawyer and acquitted. This decision transformed the criminal justice system, creating today's public defender system and ensuring that poverty alone doesn't deny justice. Story 13. Schenck v. United States, 1919. The defense attorneys, representing Charles Schenck and Elizabeth Baer, faced a challenging case during World War I's patriotic fervor. Their clients, Socialist Party officials, had distributed leaflets urging young men to resist the military draft, arguing conscription violated the 13th Amendment. Schenck and Baer were convicted under the 1917 Espionage Act of attempting to obstruct military recruitment. Their lawyers argued the leaflets were protected political speech under the First Amendment. The case reached the Supreme Court in 1919, just months after the war's end. Justice Oliver Wendell Holmes Jr., writing for a unanimous court, upheld the convictions and established the famous clear and present danger test. Holmes wrote that free speech isn't absolute. The question is whether the words used are used in such circumstances and are of such a nature as to create a clear and present danger. He famously analogized that the First Amendment wouldn't protect someone falsely shouting fire in a theater and causing a panic. This decision shaped First Amendment jurisprudence for decades, balancing free expression against national security concerns, though later courts narrowed its application. Story 14. Tinker v. Des Moines, 1969. The lawyers representing 3 Des Moines students, John and Mary Beth Tinker and Christopher Eckhart, challenged school officials who suspended them for wearing black armbands to protest the Vietnam War in 1965. The students wore the armbands peacefully to mourn war deaths and support a Christmas truce, but school administrators, fearing disruption, suspended anyone wearing them. The students' First Amendment lawsuit was dismissed by lower courts, which sided with school authorities, but their legal team persevered to the Supreme Court. On February 24, 1969, Justice Abe Fortas delivered a landmark 7-2 decision establishing students' free speech rights. it can hardly be argued that either students or teachers shed their constitutional rights to freedom of speech or expression at the schoolhouse gate. Fortis wrote, "The court held that schools can only restrict student expression if it substantially disrupts school operations or invades others' rights. Fears of possible disturbance weren't enough." This substantial disruption test became the standard for student speech cases, affirming that public schools aren't enclaves removed from the Constitution and students retain First Amendment protections while at school. Story 15. Ex parte Milligan, 1866. Lambden Milligan's attorneys challenged his conviction by a military tribunal in Indiana during the Civil War. Milligan, a Confederate sympathizer accused of plotting to free Confederate prisoners and seize weapons, was arrested in 1864, tried by a military commission, convicted, and sentenced to death, despite civilian courts operating normally in Indiana. His lawyers filed a habeas corpus petition arguing that military tribunals lack jurisdiction over civilians where civil courts function. The case reached the Supreme Court after the war ended. In December 1866, the court delivered a powerful 9-0 decision on Milligan's right to civilian trial, though justices split 5-4 on the reasoning. Justice David Davis wrote for the majority that the Constitution cannot be suspended even during wartime, and military tribunals cannot try civilians where civilian courts operate. The Constitution is a law for rulers and people, equally in war and in peace, Davis declared. The decision established crucial limits on executive power during emergencies and protected civilian authority over military power. Though the ruling came too late to prevent Civil War-era abuses, it set enduring precedent that military justice cannot displace civilian courts when they're functioning. Story 16. Roe v. Wade, 1973. Sarah Weddington and Linda Coffey, two young Texas lawyers, represented Jane Roe, Norma McCorvey, a woman who couldn't obtain a legal abortion in Texas. State law banned abortion except to save the mother's life. The attorneys filed a class action lawsuit in 1970 against Dallas County District Attorney Henry Wade, arguing that Texas's abortion ban violated the constitutional right to privacy. A 3-judge federal panel agreed, but didn't issue an injunction. The case reached the Supreme Court, where Weddington argued twice before the justices on January 22, 1973. Justice Harry Blackmun delivered a landmark 7-2 decision, establishing a constitutional right to abortion. The court held that the Due Process Clause's liberty guarantee included a right to privacy encompassing abortion decisions. Blackmun's opinion established a trimester framework. States couldn't restrict first trimester abortions, could regulate second trimester procedures to protect maternal health, and could prohibit third trimester abortions, except when necessary to preserve the mother's life or health. For nearly 50 years, this decision governed abortion law nationwide, sparking ongoing political and legal battles, until it was overturned by Dobbs v. Jackson Women's Health Organization in 2022. Story 17. Dobbs v. Jackson Women's Health Organization, 2022. Attorneys representing Jackson Women's Health Organization, Mississippi's only abortion clinic, challenged a 2018 state law banning abortions after 15 weeks of pregnancy, well before fetal viability. The law directly contradicted Roe v. Wade and Planned Parenthood v. Casey, which prohibited states from banning pre-viability abortions. Lower courts blocked the law, but Mississippi officials appealed, explicitly asking the Supreme Court to overturn Roe. The case reached a conservative majority court in 2021. In May 2022, a draft opinion was leaked, showing the court planned to overturn Roe, an unprecedented breach. On June 24, 2022, Justice Samuel Alito's majority opinion in a 5-4 decision on the main question, 6-3 on reversing lower courts, declared that the Constitution doesn't protect abortion rights, as such rights aren't deeply rooted in American history and tradition. The court overturned both Roe and Casey, returning abortion regulation to state legislatures. Chief Justice Roberts concurred in upholding Mississippi's law, but criticized the majority for unnecessarily overturning Roe entirely. The decision immediately allowed abortion bans in nearly half the states, creating a patchwork of laws and marking the first time the Supreme Court eliminated a constitutional right. Story 18, Lawrence v. Texas, 2003. Attorneys representing John Lawrence and Tyron Garner faced a straightforward yet profound injustice. In 1998, Houston police, responding to a false weapons report, entered Lawrence's apartment and found the two men engaged in consensual sexual conduct. They were arrested and convicted under Texas's homosexual conduct law, which criminalized same-sex intimate behavior while permitting identical conduct for heterosexual couples. Their lawyers challenged this as violating the 14th Amendment's due process and equal protection clauses. The case reached the Supreme Court in 2003, presenting an opportunity to reconsider Bowers v. Hardwick, 1986, which had upheld Georgia's similar law. On June 26, 2003, Justice Anthony Kennedy delivered a landmark 6-3 decision overruling Bowers. Kennedy wrote that the liberty protected by the Constitution allows adults to choose intimate relationships in the confines of their homes and their own private lives without government interference. The decision struck down sodomy laws in 13 states, recognizing that LGBTQ+ individuals possess the same liberty interests as all Americans. This expanded constitutional privacy rights and laid groundwork for later marriage equality decisions. Story 19, United States v. Nixon, 1974. Special Prosecutor Leon Jaworski's legal team pursued an unprecedented confrontation with presidential power during the Watergate scandal. After the break-in at Democratic National Committee headquarters and subsequent cover-up, Jaworski subpoenaed White House tape recordings as evidence in the criminal trial of Nixon's aides. President Richard Nixon refused, claiming executive privilege protected the tapes from judicial review. Nixon's attorneys argued the president alone decides what materials remain confidential. The legal battle reached the Supreme Court with extraordinary speed during summer 1974. On July 24, 1974, Chief Justice Warren Burger delivered a unanimous 8-0 decision. Justice Rehnquist recused. The court held that while executive privilege exists, it's not absolute and must yield to the criminal justice system's need for evidence. Burger wrote that the president is not above the law and ordered Nixon to release the tapes. The recordings revealed Nixon's personal involvement in the cover-up. 16 days later, facing certain impeachment, Nixon became the first president to resign. This landmark decision established crucial limits on executive power and affirmed that no one, including the president, is above judicial authority. Story 20, Bush v. Gore, 2000. The 2000 presidential election created an unprecedented legal crisis when Florida's vote count separated George W. Bush and Al Gore. By mere hundreds of votes, Gore's attorneys requested manual recounts in several counties, which Florida's Supreme Court ordered statewide. Bush's legal team, led by Theodore Olson, appealed to the U.S. Supreme Court, arguing that different counting standards across counties violated the Equal Protection Clause. The nation waited as lawyers from both sides argued before the justices on December 11, 2000. On December 12th, in a controversial 5-4 decision released at 10 p.m., the court halted the recount, effectively awarding Florida and the presidency to Bush. The unsigned per curiam opinion found that varying recount standards violated equal protection, but controversially stated the ruling applied only to this case. Justice Stevens' dissent warned that the identity of the loser is perfectly clear. It is the nation's confidence in the judge as an impartial guardian of the rule of law. The decision ended the closest presidential election in American history, sparking lasting debate about the court's role in political disputes and the legitimacy of the outcome. Story 21, Tobacco Master Settlement Agreement, 1998. State attorneys general from 46 states, led by Mississippi's Mike Moore and Minnesota's Hubert Humphrey III, launched unprecedented litigation against the tobacco industry in the 1990s. Their legal teams documented how cigarette manufacturers had deliberately concealed smoking's health dangers for decades while marketing to children. The states sought to recover billions in Medicaid costs spent treating smoking-related illnesses. After 4 states, Mississippi, Florida, Texas, and Minnesota, won individual settlements totaling over $35 billion, the remaining attorneys general negotiated collectively. On November 23, 1998, they reached the Master Settlement Agreement with Philip Morris, R.J. Reynolds, Brown and Williamson, and Lorillard, the 4 largest tobacco companies. The settlement required the industry to pay $206 billion over 25 years, plus additional payments in perpetuity, making it the largest civil litigation settlement in U.S. history. The agreement also restricted youth-targeted advertising, banned outdoor tobacco billboards, prohibited cartoon characters like Joe Camel, and funded anti-smoking campaigns. While states didn't spend settlement funds as originally envisioned for tobacco prevention, smoking rates dropped dramatically. The settlement established a powerful precedent for holding corporations accountable for public health costs. Story 22, Enron Shareholder Litigation, 2001 through 2006. Attorneys representing thousands of investors who lost life savings when Enron collapsed pursued one of history's largest corporate fraud cases. Enron's 2001 bankruptcy revealed that executives had systematically deceived shareholders through accounting fraud, hiding billions in debt through complex off-balance sheet partnerships. The company's stock plummeted from $90 to pennies, evaporating $74 billion in market value. Lead plaintiffs' lawyers filed massive securities fraud class actions against Enron executives, Arthur Andersen accounting firm, and financial institutions that facilitated the fraud. The legal team spent years piecing together the conspiracy, uncovering emails and documents showing executives knew Enron was a house of cards. Banks including Citigroup and J.P. Morgan settled for billions, acknowledging they'd helped structure fraudulent transactions. Arthur Andersen collapsed after criminal conviction for destroying documents. In 2006, after complex litigation, the legal team secured a $7.2 billion settlement fund for shareholders, one of the largest securities fraud recoveries ever. Enron executives Kenneth Lay and Jeffrey Skilling were convicted of fraud and conspiracy. The case led to the Sarbanes-Oxley Act of 2002, which imposed stricter corporate governance and accounting standards, transforming how public companies operate and report finances. Story 23, Liebeck v. MC Donald's, 1992. 79-year-old Stella Liebeck's attorneys took on what seemed like a simple product liability case, but uncovered shocking corporate negligence. In 1992, Liebeck purchased coffee at a MC Donald's drive-thru in Albuquerque. When she tried to add cream and sugar, the coffee spilled on her lap, soaking through her sweatpants and causing third-degree burns over 6% of her body. She required skin grafts, was hospitalized for 8 days, and endured permanent scarring. Her lawyer, Reed Morgan, discovered that MC Donald's served coffee at 180 to 190 degrees Fahrenheit, significantly hotter than home-brewed coffee and hot enough to cause serious burns in seconds. Internal documents revealed MC Donald's had received over 700 previous burn complaints, but refused to lower coffee temperature because it stayed fresh longer. Liebeck initially sought only $20,000 for medical expenses, but MC Donald's offered just $800. At trial, jurors were appalled by the company's callousness. They awarded $200,000 in compensatory damages, reduced to $160,000 for comparative fault, and $2.7 million in punitive damages, 2 days of MC Donald's coffee revenue. The judge reduced this to $480,000, and the case settled confidentially. Despite mockery as a frivolous lawsuit, the case led to improved product safety warnings and lower coffee temperatures. Story 24. Asbestos litigation. 1970s through present. Lawyers representing workers dying from mesothelioma and lung cancer launched what became the longest-running mass tort litigation in American history. Starting in the 1970s, legal teams documented how asbestos manufacturers had known since the 1930s that their products caused fatal diseases, but concealed this from workers and the public. Companies like Johns Manville, Reshaped Manhattan, and W.R. Grace had suppressed medical studies showing asbestos fibers caused cancer and asbestosis. The litigation strategy combined individual personal injury suits with class actions against multiple defendants. As evidence mounted of decades-long corporate cover-ups, juries awarded massive verdicts. Johns Manville, once a Fortune 500 company, filed bankruptcy in 1982 despite being profitable. It faced 16,500 lawsuits and counting. Courts established bankruptcy trusts to compensate victims, while allowing some companies to continue operating. Over 600,000 people filed claims, with compensation exceeding $80 billion, making it the most expensive civil litigation in history. The cases transformed product liability law, establishing stricter standards for corporate disclosure of product dangers. Though asbestos use declined dramatically in the U.S., new cases continue as diseases have 20 to 50-year latency periods, ensuring litigation will persist for decades. Story 25. Tracy Morgan v. Walmart. 2014. Attorneys representing comedian Tracy Morgan and other victims of a horrific truck accident pursued accountability from retail giant Walmart. On June 7, 2014, Morgan was traveling on the New Jersey Turnpike when a Walmart truck driver, who hadn't slept in over 24 hours, slammed into the limousine at 65 miles per hour, causing a multi-vehicle crash. Morgan suffered traumatic brain injury, broken ribs, and leg injuries requiring months of rehabilitation. Comedian James McNair was killed. Morgan's legal team investigated and discovered the truck driver had been awake for over 28 hours and had commuted 700 miles from his home before starting his 14-hour shift, a clear violation of federal hours of service regulations. The lawyers documented how Walmart's logistics system pressured drivers to meet unrealistic schedules, contributing to dangerous fatigue. Rather than fight in court, Walmart quickly settled with Morgan for an undisclosed amount, reportedly exceeding $90 million. The company also settled wrongful death claims from MC Nair's family. The case exposed widespread problems in the trucking industry, where driver fatigue causes thousands of accidents annually. It led to increased scrutiny of corporate practices that prioritize delivery schedules over safety, spurring stronger enforcement of federal trucking regulations. Story 26. Firestone Ford tire recall litigation. 2000. Lawyers representing families whose loved ones died in SUV rollover crashes uncovered a deadly corporate cover-up involving Firestone tires and Ford Explorers. Beginning in the late 1990s, attorneys documented hundreds of accidents where Firestone ATX and Wilderness tires experienced tread separation, causing Ford Explorers to roll over. By 2000, legal teams had linked the defects to at least 271 deaths and 800 injuries. Their investigation revealed both companies knew about the problem for years. Internal documents showed engineers had identified design flaws as early as 1996, yet both companies concealed the dangers from regulators and consumers. Ford had recommended unusually low tire pressure for Explorers to improve ride quality, but this increased overheating and blowout risks. In August 2000, facing mounting lawsuits and public pressure, Firestone recalled 6.5 million tires, one of the largest recalls in history. Multi-million-dollar wrongful death settlements followed. Ford eventually severed its century-old relationship with Firestone, blaming tire defects, while Firestone blamed Explorer design. The litigation led to the Transportation Recall, Enhancement, Accountability, and Documentation, TREAD, Act in 2000, requiring faster reporting of safety defects and establishing penalties for concealing known dangers. Story 27. Microsoft Antitrust Case, 1990-8 through 2001. Department of Justice attorneys, joined by 20 state attorneys general, filed groundbreaking antitrust charges against Microsoft in 1998. The legal team alleged that Microsoft illegally maintained its operating system monopoly by bundling Internet Explorer browser with Windows and engaging in anti-competitive practices to crush rivals like Netscape. Lead trial lawyer David Boies presented damaging evidence, including internal Microsoft emails showing executives discussing strategies to cut off Netscape's air supply. The trial revealed how Microsoft threatened PC manufacturers who wanted to install competing browsers, used exclusive contracts to dominate the browser market, and extended its OS monopoly into new markets. In June 2000, Judge Thomas Penfield Jackson ruled Microsoft had violated the Sherman Antitrust Act and ordered the company split into two entities. However, the Court of Appeals overturned the breakup order, criticizing Jackson's conduct, though it affirmed Microsoft's antitrust violations. In 2001, Microsoft settled with the Bush administration, agreeing to share APIs with competitors and accept oversight. The company paid $750 million in related settlements. Though Microsoft avoided breakup, the case set crucial precedents for tech regulation and influenced later antitrust actions against Google, Apple, Facebook, and Amazon. Story 28. Jensen v. Evelith Taconite Company, 1988. Lois Jensen's attorney took on the first sexual harassment class action lawsuit in American history, representing female minors who faced appalling abuse at Minnesota's EVTAC mine. Starting in 1975, Jensen and 14 other women endured years of extreme harassment, groping, sexually explicit graffiti with their names, crude pranks, threats, and retaliation when they complained. Male supervisors and co-workers created a hostile environment designed to drive women from traditionally male jobs. The legal team filed suit in 1988, documenting patterns of abuse management ignored or encouraged. Mining companies fought aggressively, employing delay tactics and attacking victims' credibility. The case dragged through courts for over a decade, facing hostile judges who dismissed the severity of the harassment. Defense attorneys put the women's personal lives on trial in brutal depositions. Finally, on the eve of a 1999 jury trial, Evelith settled, providing monetary damages to all 15 women and agreeing to implement anti-harassment policies. The case established crucial precedent that employers can be held liable for tolerating sexual harassment. It inspired the movie North Country starring Charlize Theron and paved the way for stronger workplace protections, influencing how courts and employers handle harassment complaints. Story 29. Phillips v. Martin Marietta Corp., 1971. Ida Phillips's attorney challenged Martin Marietta's hiring policy that explicitly treated men and women differently. The aerospace company refused to hire women with preschool-age children, while freely hiring men with young children, a blatant double standard based on gender stereotypes about parenting. Phillips denied employment because she had young children, sued under Title VII of the Civil Rights Act of 1964, which prohibited employment discrimination based on sex. Lower courts sided with Martin Marietta, accepting the company's argument that motherhood affected women's job performance differently than fatherhood affected men's. The legal team appealed to the Supreme Court, arguing this sex plus discrimination, treating women with children differently than men with children, violated Title VII. On January 25, 1971, the Supreme Court unanimously agreed in a landmark decision. Chief Justice Berger's brief per curiam opinion held that employers cannot have different hiring policies for men and women based on parental status without business necessity proof. Justice Marshall's concurrence emphasized that assumptions about women as primary caregivers cannot justify discrimination. This decision was among the first Supreme Court rulings applying Title VII sex discrimination prohibitions, establishing that stereotyping about gender roles violates civil rights laws. Story 30. Reed v. Reed, 1971. Sally Reed's attorney challenged an Idaho law that automatically preferred men over women as estate administrators. When the Reeds' adopted son died without a will, both parents petitioned to administer his small estate. Idaho law stated that males must be preferred to females when competing applicants had equal claims. The probate court appointed Sally's estranged husband Cecil solely because of his sex. Sally Reed's legal team, with assistance from future Supreme Court Justice Ruth Bader Ginsburg, argued this violated the 14th Amendment's Equal Protection Clause. Lower courts upheld the law, citing administrative convenience. Having an automatic preference avoided hearings to determine the better administrator. On November 22, 1971, Chief Justice Burger delivered a unanimous Supreme Court decision, striking down the law. For the first time in U.S. history, the court ruled that arbitrary sex-based classifications violated equal protection. Burger wrote that Idaho's law gave a mandatory preference to members of either sex over members of the other, based on criteria wholly unrelated to the objective of efficient administration. Though modest in scope, this groundbreaking decision opened the door for Ginsburg and others to dismantle hundreds of laws treating women as legal inferiors. Story 31, Massachusetts v. Environmental Protection Agency, 2007. Lawyers representing Massachusetts and 11 other states challenged the EPA's refusal to regulate greenhouse gas emissions from vehicles. After environmentalists petitioned the EPA in 1999 to regulate carbon dioxide under the Clean Air Act, the agency under President Bush denied the petition, claiming it lacked authority and that regulating would interfere with the president's climate negotiations. The state's legal team argued the EPA was ignoring clear scientific evidence of climate change and shirking its statutory duty. The case reached the Supreme Court in 2006. Justice John Paul Stevens delivered a landmark 5-4 decision on April 2, 2007. The court held that greenhouse gases are pollutants under the Clean Air Act, giving EPA authority to regulate them. Stevens rejected EPA's policy-based refusal, writing that the agency must make scientific determinations about whether greenhouse gases endanger public health and welfare. Crucially, the court found Massachusetts had standing to sue based on its stake in protecting coastal lands from rising seas. The dissent, led by Chief Justice Roberts, argued states lacked standing and EPA deserved deference. This decision transformed climate law, establishing EPA's authority to regulate carbon emissions and opening the path for broader climate action. Those subsequent rulings have limited EPA's regulatory reach. Story 32, TVA v. Hill, 1978. Attorneys representing environmental groups challenged the Tennessee Valley Authority's nearly completed Tellico Dam, which would destroy the habitat of the snail darter, a tiny endangered fish. After years of construction and $100 million spent, the discovery of this rare species triggered Endangered Species Act protections. Environmental lawyers argued the ESA required halting the dam to prevent extinction. TVA countered that Congress couldn't have intended the act to stop major federal projects over a 3-inch fish, citing the enormous sunk costs and economic benefits. The case reached the Supreme Court in 1978. Chief Justice Warren Burger delivered a 6-3 decision that shocked many with its literal reading of the statute. Burger held that the ESA's language was clear. Congress had spoken in the plainest of words that species preservation is paramount. The court found that the act's purpose was to halt and reverse the trend toward species extinction, whatever the cost. This meant stopping even a nearly finished dam. The dissent argued Congress never intended such absurd results. The ruling proved the ESA had real teeth, forcing federal agencies to take species protection seriously. However, Congress quickly amended the law to exempt Tellico Dam. Despite this, TVA v. Hill established that environmental laws must be enforced as written, not softened by cost-benefit analyses. Story 33. Sierra Club v. Morton, 1972. Sierra Club's attorneys challenged the Forest Service's approval of a massive ski resort in California's Mineral King Valley, a pristine area of Sequoia National Forest. Walt Disney Enterprises planned to build a $35 million resort with hotels, restaurants, and ski facilities that would bring 14,000 daily visitors to this remote wilderness. The legal team argued this violated conservation laws and would irreparably harm the environment. However, the case created a crucial threshold question. Did an environmental organization have standing to sue? The government argued Sierra Club hadn't shown injury to its members. In 1972, Justice Potter Stewart delivered a 4-3 decision that reshaped environmental law. The court held that Sierra Club lacked standing because it claimed injury to the environment itself, rather than injury to its members. However, Stewart's opinion affirmed that environmental plaintiffs could sue if they showed their members used and enjoyed the affected area. This established the principle that citizens have rights to judicial review in environmental cases, a major victory despite losing this particular case. Justice Douglas's famous dissent argued trees and natural objects should have legal standing. Though Sierra Club lost on standing, they refiled with proper allegations and ultimately won, saving Mineral King. The decision opened courthouse doors to environmental litigation nationwide. Story 34. Chevron USA, Inc. v. Natural Resources Defense Council, 1984. Lawyers for the Natural Resources Defense Council challenged EPA's regulatory interpretation during the Reagan administration's effort to relax environmental rules. The dispute centered on EPA's definition of stationary source under the Clean Air Act's permit program. NRDC argued EPA's broad bubble concept, treating an entire plant as one source, rather than each pollution-emitting device, illegally allowed increased pollution. The legal issue reached the Supreme Court. How much deference should courts give agency interpretations of ambiguous statutes? Justice Stevens delivered a unanimous decision on June 25, 1984, establishing what became known as Chevron deference, one of the most influential doctrines in administrative law. The court created a two-step test. First, is the statute's language clear? If yes, that meaning controls. If ambiguous, courts must defer to the agency's reasonable interpretation. Stevens reasoned that agencies have expertise and political accountability that courts lack. This framework governed administrative law for 4 decades, generally favoring agency interpretations over judicial second-guessing. However, in 2024, the court overruled Chevron in Loper Bright Enterprises v. Raimondo, holding that courts should interpret statutes independently. During its reign, Chevron profoundly shaped regulatory law across all federal agencies. Story 35. Friends of the Earth v. Laidlaw, 2000. Environmental lawyers representing Friends of the Earth pursued Laidlaw Environmental Services for repeatedly violating its Clean Water Act permit by discharging excessive mercury and other pollutants into South Carolina's North Tyga River. Despite documented violations, Laidlaw argued the case was moot because it had stopped the pollution and closed the facility. The company also claimed Friends of the Earth lacked standing because members suffered no concrete injury. The violations hadn't measurably harmed water quality. The legal team presented affidavits from members who stopped using the river for recreation due to pollution concerns. This case tested whether citizens could enforce environmental laws through civil suits. On January 12, 2000, Justice Ginsburg delivered a 7-2 decision expanding citizen enforcement powers. the court held that members' reduced recreational use was sufficient injury for standing, even without proof of actual environmental harm. Ginsburg rejected the mootness argument, noting Laidlaw only stopped polluting after the lawsuit was filed and could resume violations. The decision strengthened the Clean Water Act's citizen suit provision, establishing that environmental groups can hold polluters accountable when government agencies fail to act. This empowered citizens to serve as private attorneys general, making corporate polluters face legal consequences beyond government fines, a crucial tool for environmental protection. Story 36, Sackett v. EPA, 2023. Property owners Michael and Chantel Sackett hired lawyers after EPA ordered them to halt construction on their residential lot near Priest Lake, Idaho, claiming it contained protected wetlands under the Clean Water Act. The Sackett's property, separated from the lake by a road and other developed lots, seemed like typical residential land. Yet EPA asserted jurisdiction, requiring an expensive permit and restoration. Their attorneys argued EPA was overreaching, claiming the act only covered truly aquatic areas, not isolated wetlands with no surface water connection. After years of litigation, the case reached the Supreme Court in 2022. Justice Alito delivered a 5-4 decision on May 25, 2023, dramatically curtailing federal wetlands protections that had existed for decades. The court ruled that the Clean Water Act covers only wetlands with a continuous surface connection to larger bodies of water, not wetlands with mere subsurface or chemical connections. Alito rejected EPA's interpretation based on ecological relationships, instead relying on dictionary definitions of adjacent. The decision eliminated federal protection for millions of acres of wetlands, reversing EPA and Army Corps policies under multiple administrations. Environmentalists warned this would accelerate wetlands destruction, while property rights advocates celebrated limiting federal regulatory reach over private land. Story 37, United States v. Google, 2024. Department of Justice attorneys, representing the government since 2020, pursued Google for maintaining an illegal monopoly in online search. The legal team presented evidence that Google controlled 90% of the search engine market through exclusivity agreements with device makers and browsers. The company paid Apple $18 billion in 2021 alone to remain the default search engine on iPhones, blocking competitors like Microsoft's Bing from reaching users. Google also paid $26.3 billion total that year to various companies ensuring its default status. The trial revealed internal Google documents discussing strategies to maintain dominance. Google's defense argued their search engine was simply superior. Users chose Google because it delivered better results, and changing default settings was easy. The company claimed that paying for distribution was standard business practice, not anti-competitive behavior. On August 5, 2024, Judge Amit Mehta delivered a landmark decision finding Google illegally maintained its search monopoly. Mehta wrote that Google's exclusionary agreements created barriers preventing rivals from competing effectively. This was the first major antitrust victory against a tech giant since Microsoft. The ruling sets crucial precedent for pending cases against Apple, Amazon, and Meta, potentially reshaping how dominant technology platforms operate and compete. Story 38, a TNT breakup. 1984. Department of Justice attorneys spent years prosecuting AT&T's monopoly over American telephone service. Filed in 1974, the antitrust case alleged AT&T illegally maintained its control over local and long-distance telephone service, equipment manufacturing through Western Electric, and research through Bell Labs. The company controlled 80% of U.S. phone service and all local phone networks. The legal team argued this vertical integration prevented competition and innovation. AT&T fought vigorously, claiming its monopoly ensured universal, reliable service at reasonable rates. After 8 years of complex litigation involving thousands of documents and expert witnesses, the case was heading toward a lengthy trial. In 1982, facing likely defeat, AT&T agreed to a consent decree requiring the most significant corporate breakup in American history. On January 1st, 1984, AT&T split into 7 regional Baby Bells that handled local service, while AT&T retained long-distance operations and Bell Labs. The lawyers achieved a restructuring that transformed telecommunications. While the immediate goal was lower long-distance rates, the most important consequence was opening markets to competition. This created opportunities for companies that became early internet providers and cellular networks. The breakup unleashed technological innovation that wouldn't have occurred under monopoly control, fundamentally enabling today's digital economy. Story 39. Epic Games v. Apple. 2021. Epic Games' legal team challenged Apple's App Store monopoly and its 30% commission on in-app purchases. In August 2020, Epic deliberately violated App Store rules by implementing direct payments in Fortnite, bypassing Apple's system. Apple immediately removed Fortnite. Epic's lawyers filed suit within hours, arguing Apple illegally tied its payment processing to App Store access, violated antitrust laws, and harmed consumers through inflated prices and restricted choices. They presented evidence that Apple's fees were excessive, and its restrictions prevented competition. Apple's attorneys defended the integrated ecosystem, arguing their platform investments, security measures, and user experience justified the fees. They claimed Epic simply wanted free access to Apple's 1 billion customers without compensating for the platform. After a 3-week trial, Judge Yvonne Gonzalez-Rogers delivered a split decision in September 2021. She rejected most of Epic's antitrust claims, finding Apple didn't have a monopoly in mobile gaming. However, she ruled Apple's anti-steering provisions, preventing apps from telling users about cheaper payment options outside the App Store, violated California's unfair competition law. The court ordered Apple to allow external payment links. Both sides appealed, with the case still unresolved. Though Epic largely lost, the litigation increased scrutiny of App Store practices globally. Story 40. TikTok v. Garland. 2025. TikTok's attorneys mounted an aggressive defense after Congress passed a law in 2024 requiring Chinese parent company ByteDance to sell TikTok or face a ban in the United States. The legal team argued this was an unconstitutional bill of attainder targeting a specific company, violated First Amendment rights of TikTok's 170 million American users, and exceeded Congress's authority. They presented evidence that the law would eliminate a major platform for speech and expression. The government's lawyers countered that national security concerns justified the requirement. Chinese government access to American users' data and potential content manipulation posed threats that outweighed First Amendment interests. They argued this wasn't about speech content, but data security and foreign influence. The D.C. Circuit Court expedited the case, given the looming ban deadline. On December 6, 2024, a 3-judge panel unanimously upheld the law, finding Congress had authority to address national security threats, and the law was carefully tailored. TikTok immediately appealed to the Supreme Court. On December 18, 2024, the Supreme Court held oral arguments. On January 17, 2025, the court upheld the ban law, rejecting TikTok's First Amendment challenge. The unprecedented decision confirmed government power to restrict foreign-owned platforms based on national security, profoundly impacting digital speech rights and technology regulation. Story 41. AJT Osseo Area Schools. 2025. Attorneys representing a Minnesota student with severe epilepsy challenged the discriminatory legal standard school districts had been using for decades. The young student, identified as AJT, suffered frequent morning seizures that delayed her school day. causing her to receive only half the instructional time of peers. Her parents requested evening makeup instruction as a reasonable accommodation, but Osseo area schools refused. The family sued under the Americans with Disabilities Act and Section 504 of the Rehabilitation Act. However, the Eighth Circuit applied a heightened bad faith, or gross misjudgment standard, requiring proof that school officials acted with dishonesty or ill will, not just that they failed to accommodate. This standard, unique to education cases, didn't exist in employment or housing discrimination suits. The legal team argued this double standard violated disabled students' equal protection. On June 20th, 2025, the Supreme Court unanimously agreed in a 9-0 decision. Justice Sotomayor's opinion held that students with disabilities shouldn't face a higher burden proving discrimination than adults in other settings. The decision rejected the bad faith standard, establishing that the same deliberate indifference standard applies regardless of where discrimination occurs. This landmark ruling strengthened protections for millions of disabled students, making it easier for families to hold schools accountable for failing to provide required accommodations. Story 42. Perez v. Sturgis, Public Schools, 2023. Miguel Perez's attorneys addressed a procedural barrier preventing disabled students from seeking full justice. Perez, who is deaf, attended Michigan's Sturgis Public Schools, which failed to provide a qualified sign language interpreter as required by his Individualized Education Program, IEP. For years, his schools assigned an aide who knew minimal sign language, denying him meaningful access to education. After graduating functionally illiterate, Perez sued under the Americans with Disabilities Act, seeking monetary damages for the permanent harm. The school district argued he should have exhausted administrative remedies under the Individuals with Disabilities Education Act, IDEA, before filing in federal court, and that IDEA's exhaustion requirement barred his ADA claim. Lower courts dismissed his suit. The legal team appealed, arguing IDEA's exhaustion requirement only applies to relief IDEA provides: compensatory education, tuition reimbursement, attorney's fees. IDEA doesn't offer monetary damages for past discrimination, only remedies going forward. On March 21, 2023, Justice Gorsuch delivered a unanimous 9-0 decision. The court held that students can pursue ADA damages in federal court without exhausting IDEA procedures when seeking relief IDEA doesn't provide. This opened a crucial avenue for disabled students to recover compensation for permanent harms, complementing rather than replacing IDEA protections. Story 43. Park v. Pennsylvania, 1971. Lawyers representing the Pennsylvania Association for Retarded Children filed a groundbreaking class action lawsuit challenging state laws that excluded children with intellectual disabilities from public education. Pennsylvania law allowed schools to deny admission to children who hadn't reached a mental age of 5 years by first grade, and to exclude those deemed unable to profit from public school attendance. This affected over 150,000 children with intellectual disabilities across the state who were denied any educational services. The legal team argued this violated the 14th Amendment's due process and equal protection clauses, presenting expert testimony showing that all children with intellectual disabilities could benefit from education and training. The three-judge district court heard evidence demonstrating that these children's exclusion harmed both them and society. On October 7, 1971, the court approved a landmark consent agreement, essentially a settlement, with the force of a judicial order. Pennsylvania agreed to provide free, appropriate public education to all children with intellectual disabilities, regardless of severity. The state committed to education programs appropriate to each child's learning capacity. This decision was revolutionary, establishing for the first time that disabled children have a constitutional right to education. Park directly influenced the Federal Individuals with Disabilities Education Act, IDEA, passed in 1975, transforming special education nationwide and ensuring millions of disabled children receive educational services. Story 44. Near v. Minnesota, 1931. J. Neer's attorney challenged a Minnesota law allowing judges to shut down publications deemed malicious, scandalous, and defamatory as public nuisances. Neer published the Saturday Press, a Minneapolis weekly that attacked local officials as corrupt and linked to organized crime, using inflammatory and prejudiced language. County prosecutors obtained an injunction shutting down the paper under the Public Nuisance Law of 1925, which Minnesota courts upheld. The legal team argued this was prior restraint, government censorship before publication, violating the First Amendment's press freedom guarantee. The case reached the Supreme Court in 1931. Chief Justice Charles Evans Hughes delivered a landmark 5-4 decision striking down Minnesota's law. Hughes held that the First Amendment applied to states through the 14th Amendment, prohibited prior restraints except in extraordinary circumstances like wartime military secrets or obscenity. He wrote that liberty of the press includes immunity from previous restraints or censorship. The remedy for irresponsible journalism is subsequent punishment for defamation, not government censorship. This decision established foundational press freedom principles that would later protect the Pentagon Papers and countless investigative journalism exposes. Despite the 5-4 decision, Neer v. Minnesota became one of history's most important First Amendment cases, ensuring government cannot silence publications before they speak, even when the content is offensive or critical of officials. Story 45, Citizens United v. FEC, 2010. Attorneys representing Citizens United, a conservative nonprofit, challenged federal campaign finance restrictions after the Federal Election Commission blocked their film Hillary, the movie during the 2008 primary election. The documentary was critical of Hillary Clinton, and broadcasting it within 30 days of primaries violated the Bipartisan Campaign Reform Act's restrictions on corporate electioneering communications. The legal team argued these restrictions violated Citizens United's First Amendment rights. Corporations should have the same speech rights as individuals, and political speech deserves the highest constitutional protection. The government defended the limits as necessary to prevent corruption and preserve electoral integrity. On January 21, 2010, Justice Anthony Kennedy delivered a controversial 5-4 decision that transformed American campaign finance. The court held that political spending is protected speech and that the government cannot restrict independent political expenditures by corporations, unions, or associations. Kennedy wrote that speech restrictions based on the speaker's corporate identity violated the First Amendment. If the First Amendment has any force, it prohibits Congress from fining or jailing citizens or associations of citizens for simply engaging in political speech. The dissent, led by Justice Stevens, warned this would unleash corporate money corrupting democracy. The decision led to the Super PAC era, fundamentally changing American politics by allowing unlimited spending by outside groups, though disclosure requirements and direct contribution limits remain.